Teacher's testimony recounting child's allegations of abuse violates Confrontation Clause. State of Ohio v. Darius Clark. Case number 2012-0215. 8th District Court of Appeals, Cuyahoga County.
Now here's a teacher, a very impressive profession on the stand, and so suddenly that testimony, that if you were there and watched what the child said, might seem a bit soft or equivocating, becomes very compelling when repeated through the voice of a professional adult.
This child, LP, was of such tender years that he was incompetent to testify at trial. There's 3 prongs to being competent to testify, as the court is well aware. You have to be able to correctly perceive, you have to be able to correctly remember, you have to be able to correctly relate. The trial judge in this case made the determination that this child could not accomplish those tasks. Now, the trial judge turns around and says, even though this child is not cognitively developed enough to be able to give us reliable testimony in a court of law, I'm going to allow in statements that were made at an even earlier time in this child's cognitive development. When the state says that the Sixth Amendment is not about reliability, respectfully, they're wrong. Confrontation is about reliability. It's about reliability measured in one particular manner, the crucible of cross-examination.
The admissibility of statements under the Confrontation Clause is determined by the primary purpose for which those statements are made. When a teacher observes an injured student and asks that student how those injuries occurred, the resulting statements are non-testimonial and their admission is not barred by the Confrontation Clause. This was a teacher doing what teachers do every day, and that is to look out for the health and well-being of their students. And that responsibility, that professional responsibility, exists entirely independent of any mandatory reporting obligation.
The Supreme Court of Ohio ruled on October 30th, 2013, that the Confrontation Clause of the U.S. Constitution bars the admission of statements made by a 3-year-old child to a preschool teacher identifying an alleged perpetrator of child abuse when there is no ongoing emergency and when the teacher acts with the primary purpose of gathering information related to past criminal conduct. The Confrontation Clause requires that criminal defendants have the opportunity to cross-examine witnesses against them at trial and applies to testimonial statements made to prove or establish past events potentially relevant to later criminal prosecution. In a 4-3 majority opinion authored by Justice Terrence O'Donnell, the court held that a teacher acts in a dual capacity as an instructor and as an agent of the state for law enforcement purposes when questioning a child about suspected abuse in furtherance of the teacher's mandatory duty to report child abuse. The decision affirms the judgment of the 8th District Court of Appeals, which reversed the convictions of Darius Clark of Cleveland for felonious assault, endangering children, and domestic violence, and returned the case to the Common Pleas Court for a new trial.